Okay, good afternoon, everybody. It seems that our colleagues from previous session had a really fruitful and long discussions, which ended exactly on 2 o'clock. So I took a liberty to give 5 minutes separation between the sessions. And we are starting the afternoon session on the European Union law and private international law. I'm pretty sure that everybody is familiar with the schedule of the speakers, but maybe let me briefly remind it. So I hope you can see my screen, and here you can see the schedule of the speakers. This is the previous session, and our session is this one. So the first speaker is Gabor Palasti, the second Francesco Salerno, then Inga Kaczewska, and the first part of the afternoon session concludes with joint presentation from Jochen Botel, me, myself, Edmunds Broks, and Christoph Schewe. We have a scheduled 3 o'clock break. Most likely we will take it a few minutes later, as I propose that each presentation is 15 minutes. And if somebody has some immediate questions, then we can go through a couple of questions right after the presentation, and only then move to the next presentation, so we can calculate roughly that the break will be a bit later. And after the break, we'll have 2 more presentations, as Irena Kucina will not be present. So we'll have, after the break, presentation from Alexander Spillers and Hanna Kovachikova. Are there any questions or any additional comments maybe at the very outset of our session? If no, then I welcome Gabor Palasti from Szeged University from Hungary. Are you here?
Hello, can you see me? Can you hear me?
Yes, Gabor, we can see you, we can hear you.
Very good. Thank you very much. Thank you very much for the invitation. I really appreciate to have been addressed and approached. And I remember a few months ago, we had a very interesting conference with Professor Arne Tuka, Professor Inga Kaczewska, Professor Vadim Mantrov, amongst others, about an EU Commission funded survey about the courtroom application of EU private international regulations. And the bottom line was that there's so much going on in this field, so many new developments that it would take probably endless conferences and meetings to be able to discuss at least some part of it. Now, I attempt to share, yes, can you, let me have a feedback from somebody. Can you see the slide? In principle, I shared the slide with...
Yes, we can see the slides.
Very good, thank you very much. Okay. My subject matter is what is the moving space, the legislative space for member states over their own domestic conflict of laws acts regarding general matters of private international law. In recent years, there have been a number of member state private international law codes or acts that were codified and entered into force. Most of these were actual recodifications of earlier existing domestic private international law codes. Here is the list of the most recent ones. I myself took part in codifying the Hungarian Act. It took about 2 years, and I was sitting there in the committee of the Ministry of Justice. And the main reason for this process of codification, or better to say recodification, is that the number of EU regulations basically split up the already existing structure of domestic private international law from a number of different aspects. I listed the most well-known ones: Rome to European succession regulation, then the matrimonial property regime and the registered partnership regime regulation. And there's a proposal for third-party effects of assignment of claims, all relating to conflict of laws rules, the connecting factors, and also a number of international conventions contain also applicable law provisions. Thinking about, for example, the Hague Protocol about maintenance, some IP conventions, very seldom and occasionally some contract law conventions, substantive law conventions also contain conflict of laws provisions. And because of the uniform and autonomous interpretation of these sources for characterization, which means how do you characterize the legal problem which you receive, which is traditionally based on the law of the forum and based upon its own concepts, deeply rooted in domestic private law, and also the uniform and autonomous connecting factors did override the already existing structure and solutions of the member states' private international law codes, and created sometimes parallel situations, sometimes irreconcilable situations, not only focusing just on those matters which are regulated, for example, for contracts Rome 1, which then overrides and conflicts with the member states' connecting factors for contracts, but the entire wider structure and buildup of domestic private international law. For example, for a member state that heavily relies on nationality of persons, both for natural and legal persons, then even for those matters which fall outside the scope of these regulations, it breaks up the structure of domestic private international law. If for their other legal relations covered by the regulations, nationality is not anymore relevant, and it's replaced by habitual residence, for example. So the whole structure of private international law had to be reshaped following these regulations. Our Act of 2017 replaced Act Decree 13 of 1979. Both of these legal sources cover both conflict of laws as international civil procedural provisions, and both of them had a very systematic structure. I will focus only on conflict of laws, where there's a general part and named legal relations. Already the 1979 Act Decree had special conflict of laws rules for persons, law of property, law of things, intellectual property, obligations, both contractual and non-contractual, inheritance, family law, and a special chapter for labor law, and more or less intact structure was brought into our most recent act. There are some changes. For example, cohabitants and registered partnerships now occupy a separate chapter. It was non-existent back in 1979. Now you might wonder why a communist country in 1979 had such a well-structured and detailed private international law act when there was no freedom of movement of persons, foreign trade was state monopoly, etc. It wasn't very much in use, but it did have its reasons. For example, there were over 2 million Hungarians living outside the borders of Hungary for political and historical reasons, and all their family relations and inheritance, etc., had to be taken care of. So there had to be a conflict of laws background, even if travel was very much restricted. Also, Hungary did have a certain amount of foreign trade, not just within the Comecom system, not just within communist countries, but also to West Europe. Hungary's role was primarily to obtain COCOM listed technology from the West, which required Hungarian state companies to trade with Western counterparts, even to establish subsidies in the West, which is a very unique phenomenon. So the Act Decree did have practical use as well. And we had to turn it into a completely new act. It took about 2.5 years until we got there. The legislative competences of private international law matters of member states can basically be formed only upon material scope. Whatever is outside the scope of the regulations, either as general or because there is always a list of excluded matters in these regulations, would fall under member state competence. But for example, for matters of geographical or personal scope, there's no member state competence. All the regulations have a universal application, which excludes a parallel system of conflict of laws provisions in a member state based upon the outcome of the connection, based upon the applicable law. Also, temporal scope makes no sense, so it's only within the maneuvering space left by the rules of material scope within these regulations. Now, I will only discuss general matters of conflict of laws. That in itself is very interesting. The member state legislation needs to cover general matters, but the question is if there is a general part of conflict of laws from these regulations, even though every regulation has only a very specific subject matter, and how does this general part affect the member states' private international law rules? I divided all the rules into 4 categories. The first one is those issues which fall under general matters of private international law, which our Act decree had contained even before the 2017 Act, and to which there is also a corresponding provision in the regulations of the European Union, and how what impact they had on our laws. The first one is the scope of private international law. How do we define private international law? Most member states, just like Hungary, build up on a doctrine of a significant foreign or significant internationality element. So if there's a significant foreign element in the case, then private international rules apply. But it's not the same with EU regulations. They don't contain this traditional test. Their phrase is situations involving a conflict of laws. This is how it appears in usually Article 1 of most of the regulations or in recitals. What are the differences? After all, you might say, if there is a significant internationality element, then the situation involves a conflict of laws, so it's the same. It's not. One is the choice of law for domestic situations, such as under Rome 1, Article 3, Paragraph 3. The traditional solution, typically in most continental conflict of laws regimes, is that if the contract is entirely domestic, and the parties choose a foreign law, then there is no significant foreign element in the contract. Hence, it's called a material choice of law. Under material law, substantive civil law, and it's not a matter for private international law. Now, the problem with this is that it varied from member state to member state what additional internationality element you would have needed to qualify for a contract, for an international contract. Some countries, for example, recognize that if the choice of foreign law is coupled with the choice of a foreign jurisdiction, a choice of foreign forum, that makes a domestic contract international. Other countries, such as Hungary, rejected this approach. And if the scope of private international law is based upon a significant internationality element, then for all these domestic contracts, forum shopping would have remained possible. So another test had to be needed, and this was a situation involving a conflict of laws. The other question is the priority of substantive law conventions. The most well-known one is probably the CISG, about contracts for international sale of goods, where the starting point is that whatever is regulated by the CISG has precedence before we apply the conflict of laws rules, and the connecting factors will designate an applicable law only if the matter is not covered by substantive law convention. But this is the major, this is the generally accepted view, but there has, from the beginning on, there has always been a little but noteworthy opposition to this. And even until today, there are studies that point out that there is no real legal basis to put the conventions of substantive law before the connecting factors, and especially in connection with EU regulations. If you apply the doctrine of significant internationality element, it doesn't solve the problem, because there is a significant internationality element both for the purposes of the CISG, for example, and for the purposes of connecting factors. So the question is not answered, why is there a priority of substantive law conventions before connecting factors? But if you phrase the same thing as a situation involving a conflict of laws, then the Rome 1 regulation, for example, or any conflict of laws source of law does not apply, because conflict of law situation involves the application of foreign law. But if there is a uniform international convention, then you don't have to apply the law of a country, since there is an international convention. So then it's not a conflict of law situation. I know you can add side remarks to this. I will move on because time is limited. But for these two reasons, private international law is not based anymore on the existence of a significant internationality element, but on a situation involving a conflict of laws. This is what we put into our new act as well. The matter of characterization is the second question. Obviously, most countries start from their own legal system and they characterize the problems that appear before their courts upon their own, the law of the forum. But the EU regulations call for uniform and autonomous interpretation, which basically rebuts the rule of characterization for those matters that the regulation applies to. The most handy example, which we also use on a daily basis, is a culpa in contrahendo situation. It doesn't matter if in your country it's a contractual matter or if it is a non-contractual. The Rome 1 and Rome 2 regulations drew the line, and then that it is what it is in those regulations. And then your rule of characterization applies only if the notion doesn't fall under the requirement of uniform and autonomous interpretation of these regulations. Renvoi, remission and transmission. All the regulations have a renvoi rule, but it's not uniform. Renvoi is treated differently, for example, for Rome 1 than for the European succession regulation, but the tendency is to limit it, not to accept remission or transmission. We did take over this approach, and our act excludes renvoi as a main rule, but we still have exceptions. Public policy, all the regulations recognize public policy as an obstacle against the application of foreign law, but public policy is a matter for a member state to protect and not for the EU as such. Hence, the regulations provisions on public policy are usually limited to a few matters. It's a ground to refuse application of foreign law. It can be called only exceptionally if foreign law is manifestly contrary to the basic core values of domestic law, and only the law of the forum can refer to public policy. You cannot go for public policy of a third country. But a few issues are not covered. For example, to establish the content of public policy is always for the member state. And secondly, what is the substitute law if foreign law collides with domestic public policy? These issues we did place in our private international law. For example, for substitute law, we set up a gradual system, the end of which is the law of the forum, but it doesn't start there. It starts in the lex causae. If there is another rule in the lex causae which does not conflict with public policy, then you can opt for that before going to your law of the forum. Evasion of law, it comes from the French fraude à la loi. Ignore the connecting factor if it is manipulated. We had a general rule for this. The regulations don't contain this as a general rule, but in practice, it turned out that manipulated connecting factors usually appeared in the most number of cases appeared by way of imitating a foreign element, and that imitation was usually only a simple choice of foreign law. Now, since it applies to domestic contracts and Article 3, Paragraph 3 of Rome 1 takes care of this situation, ultimately, we deleted this rule, and it's not in our private international law act anymore. It's very rare anyway, and most of the situations were covered by Rome 1, Article 3, Paragraph 3, although it's not a rule of general character in Rome 1, but still it resulted in deleting our evasion of law provision. General choice of law by the parties, we have a provision in the Act decree that in any legal relationship in favor of Hungarian law, you can put aside foreign law. It's now deleted. Oops, I can see I have only very little time left, if any. I'll just go through this point. In the EU private international regulations, there's no general rule about this, but choice of law is extended to a number of matters other than contract. We put a general rule in our act for the recognition of choice of law in many legal relationships and unified its conditions. All right, I could go on, but I can see that I have pretty much exhausted my time. Is it so?
It is so, but if you need a sort of one conclusive slide and one conclusive comment, something like that, you can do it. Not to stop you at the middle of slide.
So this was the first category. Now, we also took over a number of novelties from EU private international regulations. They never existed in Hungarian private international law. General escape, I will just briefly flip through. General escape clause, general default rule, fallback rule for matters which are not covered. An interregional conflict of laws rule, complete novelty, comes only from the regulations. Overriding mandatory provisions, they also come from these provisions. There are a number of issues which are uncovered by the EU's private international regulations, but we did have a rule about that. Change in the applicable law. For some reason, it's not regulated in these regulations. And contents and proof of foreign law entirely left to the member states. Finally, there is one matter which is uncovered by both the EU regulations and our act. That's the matter of incidental question. So the conclusion is that the regulations do add into a general part of private international law with so many specific rules. If you put them together, and that does have an influence, and I'm sure it will be particularly useful for those countries which are yet to codify their own private international law. Thank you very much for your kind attention.
Thank you, Gabor. The presentation was quite interesting and very well structured. Also, Gabor set a really high standard for complying with time limits. I hope all the following speakers will be as example as Gabor was. Maybe there are some questions. We can make a room for one or two questions right after the Gabor's presentation. As it seems that there are no questions, then thank you once more for your presentation. And then we move to our second speaker. Our second speaker is Francesco Salerno, University of Pavia, Italy. Are you here? I can see the name Francesco Salerno appears, but can you hear us? Are you ready to? Okay, we have some chat message that there might be some technical difficulties. Yes, okay. Francesco Salerno. Okay. Yes, we can see you. We can hear you as well.
Thank you very much. Thank you very much for this invitation. I'm very glad to attend this interesting conference. I have no slides to share with you, and my argument is the challenges of the right to repair in the EU legal framework. And I would like to introduce my argument saying that while most consumers would rather repair a product than buy a new one, most of consumers' goods are in fact not built to last and cannot be easily repaired. When consumers do not have access to spare of the necessary information, they are often left with no choice but to replace the product. Some manufacturers intentionally design products to break or become unusable. Studies show that some consumers' products are specifically created to have a short lifespan that often coincides with the legal warranty period, after which the products become inefficient and obsolete. Over the years, products that not only have a short life, but are also not easy to repair have led to an economy based on disposable goods. The adverse effects have been far-reaching and have most notably impacted the environment. It is common knowledge that disposable products have led to energy waste in manufacturing, because these products cannot easily be reused, recycled, or repaired, they clog up our landfills. Faced with this situation, Europe's institutions have adopted a series of measures to create a circular system that promotes durable and repairable products. Putting into place such a system, however, requires a concerted effort A first important step in this direction has been the recent implementation of the right to repair. Originally, a response to the call for an eco-friendly economy, the right to repair seems destined to reverberate in other contexts too, particularly in the business world, the labor market, and the field of consumer rights. The need for a greener system has been particularly pressing for energy-related products, which are notorious for their intensive use of resources and requiring environmentally unsound method of disposal. In an effort to remedy this situation, the European Union issued Directive 2009/125, which has affirmed the need to regulate the design phases in order to achieve a high level of protection for the environment by reducing the potential environmental impact of energy-related products, which will ultimately be beneficial to consumers and other end users. Having acknowledged that designs needed to be more eco-friendly, the next step was to put the principle laid down in directive into practice. To this end, the Commission approved several regulations to set eco-design requirements for products that represent significant volumes of sale and trade in the EU. By focusing on a well-defined category of products, electronic motors, light sources, electronics display, washing machines, etc., these eco-design regulations have established, in addition to design rules intended to ensure product durability, a number of other obligations that apply to products even after they have been put on the market. The obligations, which apply to manufacturers as well as importers and their authorized representatives, include, for example, making specific repair information and instructions available, making replacements easier by ensuring that spare parts are accessible, ensuring that replacement can be made using common tools, providing adequate information on how to access and order spare parts, ensuring delivery to the consumer within 15 working days, and guaranteed the ready availability of spare parts for a minimum number of years after purchase of the product. While neither directive nor related regulation have expressed the pursuit of any other objectives, it is certain that the effects of the right to repair will extend beyond the environment. It is easy to foresee that the right to repair will affect, for example, production and the labor market. In all likelihood, product repairability will lead to new opportunities for artisans and small businesses, segments that have suffered over the last decades. A prime example in the energy fields is the decreasing number of firms specialized in electronic repair, the drastic disappearance of radio and TV repair shops, despite the increase in ownership of these types of goods, and the general decrease in the number of workers in this sector. And yet, the area in which the impact of the right to repair should be most evident is that of consumer rights. The bulk of the costs arising from the reduced life cycles of goods and the difficulties arising from limited repair possibilities are shouldered by consumers who are thus forced to constantly replace products. Confirming the tight link with consumerism, many member states have addressed this matter in their legislation, explicitly invoking the right to repair within the context of consumer rights. In March 2014, strengthened consumers' rights by passing legislation that requires manufacturers and importers of movable goods to provide information on the availability of spare parts, to make this information available to consumers and to provide retailers of professional repairers with the spare parts that are indispensable for the use of the goods on the market. Instead, the Swedish government has supported the right to repair through a fiscal stimulus by lowering the VAT rates on repairs of certain goods, allowing the cost of labor incurred in the repair of domestic appliances to be partially deducted from taxes, and taxing products which contain materials that are difficult to repair or recycle. Belgium, Spain, Austria have also been active in combating planned obsolescence and increasing product repairability. Regulatory amendments have also been undertaken in my country, in Italy, with a view towards raising consumers' empowerment. In Italy, the right to repair has been taken into consideration in various pieces of draft legislation presented to Parliament since 2017, and providing for modification to the Italian Consumer Code. To date, however, none of these drafts have passed through all parliamentary stages. Among these, draft law number 615, 2018, presented to the Senate, proposes to introduce, among other things, a specific obligation for manufacturers or importers to guarantee buyers an adequate technical service for long-lasting consumers' goods. In addition, this draft law proposes amendments regarding the provision of the Italian Consumer Code, which lays down the fundamental rights of consumers, proposing to add another fundamental right of consumers, the right to obtain product and service repair at affordable costs. It also proposes to require manufacturers and importers to provide spare parts for at least 5 years after goods go out of production, or in the case of spare parts for household appliances, for different periods of time proportionate to cost. Moreover, the draft law sets out that spare parts and not renewable components of consumers' goods should be made available to consumers at a fair price and in proportion to the value of the goods. The draft law includes a series of other provisions on planned obsolescence and, like the law in France, envisages criminal penalties. While much progress has been made to improve the right to repair, there is still ample room for Europe's institutions to take bolder action. Considering the narrow scope of application of the regulations described above, the first move should be to expand existing obligation to include all consumers' goods. This would mark a first and important step. Consider that current community regulations do not apply to key products like computers and like mobile phones. Indeed, initiatives aimed at widening the scope of application have already been taken by the Commission, which in its communications has underlined the need for a generalized extension of the scope of application of the Eco-Design Directive, with the aim of creating a circular economy framework within which the right to repair is applicable to the broadest possible range of products. What consequences non-compliance with right to repair obligation should lead to poses another possible challenge, given that community regulations do not seem to mention the repercussions. Identifying this could prove useful in guiding member states toward harmonization and effective application of European rules. Obviously, on the understanding that if EU regulations do not specify the legal consequences, right to repair obligations remain binding, and any non-compliance should be taken into consideration by national courts, whose duty is to guarantee the application of community obligation and also based on the principles of their national legal systems, impose the legal consequences. The biggest challenge might, however, be a cultural one and might be even more difficult to overcome as a result of the recent events brought about by the pandemic. And by this, I mean the exponential growth in all contexts and in relation to all types of goods of online sales. It cannot be excluded that this may influence the future choices of consumers and prompt them, at least in certain cases, to take the easy option of replacing a product by simply purchasing it online, rather than to search for a qualified repair to mend the item properly. Thank you very much for your attention, and I reserve to add my consideration, especially regarding my country, Italy, in my right report.
Thank you, thank you. This was a really interesting presentation, and the issue you put forward is quite a challenge of the modern world, and I hope that our grandchildren and grandchildren after them will live in a better world where planned obsolescence is somehow at least limited, if not completely fought off. I really enjoyed your presentation. Are there any questions maybe from other listeners?
Okay.
Let me see. So if somebody is willing to ask something, now is the time. Well, if there are no questions, then once more, thank you, Francesco Salerno, for your presentation.
It was a real pleasure for me.
We are moving to our third speaker, my esteemed colleague, Inga Kaczewska. Inga, are you here?
Yes, I am. Yes, I am, and I would like to share my screen.
Okay, we can see you, we can hear you, and the floor is yours.
Yes, thank you very much. Good afternoon, dear colleagues. Confucius once said that life is really simple, and we insist on making it complicated. And one of the goals of my today's presentation is to find out whether the European small claims procedure is really simplified and simple, and we make it complicated, or actually this procedure is quite complicated. I have also second aim for this presentation and upcoming article. In 2012, I and my dear colleague, Dr. Baiba Rudevska, we wrote commentaries on European procedures, including European small claim procedure. We were actually asked by European Union to write about applicability of European procedures in Latvian courts. However, at that time, we did not have any case law, practically no case law on applicability of European procedures. So therefore, there were commentaries. We made a commentaries article by article of European procedures. And I want to compare how the situation have been changed from 2012 and nowadays. And in 2012, we actually made a hypothetical cases. And now we actually see how those cases developed in practice and whether we have the same problems as we thought would be with those regulations also today. So let's see how it's have developed. I will start with very short introduction of the particular regulation. And then in the light of very small case study, I will indicate only a few problematic issues, what I have seen in practice, how the Latvian courts, for example, applied this regulation, and we'll discuss some of the particularities. So we are talking about small claims regulation. It's a regulation number 861/2007. Quite old regulation. It is applicable from the 1st January 2009, with some of the amendments made in 2017. It is intended to simplify, speed up, and reduce costs of litigations in cross-border cases. Indeed, it's a question whether there is a difference between simplifying and simple procedure. And I guess, yes, if we apply this procedure in practice, we see that we apply the simplified procedure not only in simple cases, but there might be also complicated cases, whether that's fast enough, whether that's reduced costs. Maybe on paper it does, but in practice, and I have been involved in many cases applying this regulation, no, I can't say that it doesn't speed up and it does not reduce the costs of the procedure. Yes, there you see the scope of the application of regulation. So the temporal scope, I already covered that. Territorial scope. So Denmark is not participating in the regulation. Of course, after Brexit, we will not see UK applying this regulation. Material scope, very interesting. Of course, it's civil and commercial matters, but with the thresholds up to 5,000 euros. But this regulation excludes, there's other exclusions as well, but such claims as regards employment law and violation of privacy. The regulation is open for discussion, and there should be submitted recommendations until the next year's summer regarding the changes of the regulation. And one of the questions will be whether the scope of application will be opened also for the employment law. I will not discuss about the relationship with Brussels 1 bis regulation, jurisdictional rules, and domicile. This is, of course, a claimant's choice to choose this procedure. It's form-based, and it seems that forms should help us to speed up and simplify the application of regulation. But believe me, I have asked my students to fill up the form, and it's quite difficult for even for them, for law students. And then I imagine if there is a lady from the countryside who wants to get back money for damaged shoes, and when she tries to fill up the form and she sees such words as jurisdiction, domicile, so whether that makes her life more simpler and whether she will be encouraged to get her money back. There are two cases by European Court of Justice that really doesn't help us much in theory, and especially those questions that I see as problematic. And here also, of course, I have to see how in practice those regulations are applied by the national courts. And my interest, of course, is Latvian courts. Of course, there are no special and exact statistics, how many times those regulations are applied. Publicly available are around 66 judgments. However, that's really disappointing that in those judgments, in most of them, in majority of them, 99%, the courts are not discussing why they apply and why they think that European small claims procedure applies. They never look at the scope of application. They do not see the interconnection with this regulation and Brussels 1 bis regulation. And even more, if we have no such basic information about in the judgment, there is no discussion about procedural issues or issues that are in the regulation. And more tragic is that courts tend to apply national rules, even though if regulation provides for certain rules and courts have to apply regulation. And so there is no kind of understanding where the regulation ends and where the national procedure starts. In the light of this, I would just want to introduce you with one, let's say, hypothetical case. It's a mixture of some cases that happened in my practice in the Latvian courts. And imagine that we have a Mr. Cliff, who is actually a consumer, and he took credit from Tini Credit domiciled in Lithuania. And Mr. Cliff thinks that his credit agreement is unfair. So Mr. Cliff claims to pay overpaid monies from Tini Credit and in amount of 3,000 euros. And in addition, he wants to terminate this agreement with Tini Credit. So far, so good. And so Mr. Cliff thinks that he can use the European small claims procedure, submits this application A in the Latvian court. Tini Credit is smart enough. Tini Credit brings the counterclaim exceeding the limits of this procedure, of this regulation, and brings the counterclaim of 50,000 euros for damages for any other, but just brings this claim. So when there are certain questions and issues that is raised already at this stage of proceedings, when the court receives application of the small claims procedure and receives also counterclaim. The first issue is whether Mr. Cliff can ask only monies, can ask this overpaid amounts of 3,000 euros that are within the scope of the regulation, but also whether the Mr. Cliff can ask to terminate the credit contract. So the first claim is a claim for the performance. Another claim is claim for declaratory claim. So whether declaratory claims are within the scope of this regulation. At the first, and here's like, could be two answers. And in 2012, we said, no, the declaratory claim cannot be within the scope of this regulation. But now maybe we have to change the mind. Firstly, regulation itself does not say that it applies, it just says that it applies to the claims not exceeding 5,000 euros. it does not exclude in Article 2, Part 2, the claims that are, for example, for the termination of the agreement. However, in application A, Mr. Clift had to fill out the particular section of this form, and this section asks Mr. Clift to indicate the monetary claim. So what is the amount of the monies? And he says it's 3,000 euros. But also there is a section for the other claims, and it doesn't say non-monetary claims, but it's other claims. But still, in this section, you have to indicate how much this other claim costs. So you have to express this other claim in specific amounts. And for example, if the Mr. Cliff would ask to repair some goods or exchange some goods or deliver the goods, he could express this in monies. But if he asks a court to terminate the contract, it's very difficult to evaluate and express it in a certain sum. My conclusion here would be, if this declaratory claim is supplemented with this claim in monies, then it is within the scope of the regulation. And that's also like reasonable to think that there is no need for Mr. Cliff to continue this agreement, and somehow he has to terminate it. That's the one reason. If the Mr. Cliff just asks in the claim to terminate the agreement, then this would most likely would not be within the scope of this regulation. However, there are no academic discussions. There are no case law or discussions in the judgments regarding this issue. And I have seen many cases where courts say, no, you cannot ask as a supplementary claim to terminate the agreement. So this is also, I think, very interesting question for the future and for the discussion. The second one is regarding the counterclaim. In 2012, we thought that this is really a hypothetical case when someone can submit a counterclaim that exceeds, in that time it was 2,000 euros, but this time 5,000 euros. But this is clear that in practice it happens, and especially when you have a trader, or in this case, Tini Credit, who is strongest party. And it's kind of sabotage or blackmailing of Mr. Cliff, saying, no, we want to more monies from you. You and Mr. Cliff should be scared of that, should terminate the proceedings and say, okay, I don't want to claim anything from you. But what happens here? If it's sabotage, if you see that this really counterclaim is made up of the strongest party, whether the courts can refer to another article of regulation and say that we dismiss the case because counterclaim is clearly unfounded. Is this the case? Could the court do that? The problem here is that this notion, this concept, clearly unfounded, is not autonomous in this regulation. Recital 13 provides that we have to look at our national procedural law and define whether this is clearly unfounded claim and then dismiss the case. Unfortunately, in Latvian civil procedure law, we do not know such notion, clearly unfounded claim. So therefore, for the judge, it's almost impossible, the judge should be very creative to establish what does it mean, clearly unfounded. And judge actually risks, if he denies the counterclaim in this case without really particular grounds, then respondent, of course, defendant becomes very disappointing, and it's also kind of problematic issue of this regulation. So what is this notion, clearly unfounded claim? The second issue, what we solved in 2012's commentaries, and what is actually solved also in in civil procedure law is how we transit from European small claims procedure to the national domestic civil procedure if the counterclaim exceeds the threshold of this regulation. So basically, court should put the case on hold and ask the parties to fill out the proper statement of claim with all requisites what is required by civil procedure law. And parties should submit also evidences that are supporting this claim with translations, what is not mandatory within this regulation. However, I have seen the cases in Latvia where court does not put the case on hold, but proceeds with the forms and does not ask parties submit anything else, and just hears the case on merits, but without like without like reference to any civil procedure law notions or terms. There's, of course, a lot of other issues and problematic issues concerning this regulation, what can be discussed, but I will not, in the sake of time, I will not proceed with them. Just probably one also interesting question on a discussion of applicable law, because the parties in this procedure should not give any legal grounds for the claim. So Mr. Cliff just say, you know, I want to back the money from TINI credit, but Mr. Cliff does not need to indicate any like law, and the court should find the law. So maybe not in Mr. Cliff's case, but in other case, for example, in some non-contractual case, the court finds that Zimbabwean law is applicable in accordance with Rome 1 or Rome 2 regulation. So who determines the content of Zimbabwean law? Court. And whether our court will be able to determine that within 30 days, what is obligation of the court to make a judgment in accordance with this European small claims procedure. I don't want to even talk about how we know the state fees, court fees, if we want to submit the claim in other member states, about the language issues, services documents, and of course the court's assistance. The court should help the parties to fill out the claim forms. So for example, Mr. Cliff could go to the court, Latvian court, and say, help court to fill out this application form against TINI credit. So in conclusion, I don't think that this procedure have been made so simplified. It still has a problems, especially in practice, and still our commentaries, what is really, I'm glad for that, it's still topical nowadays, even though it's like around 10 years ago we wrote those, but still there are problems, and there is need for academic discussion regarding this kind of simplified procedure. Thank you very much. Thank you, Inga. It's always great to receive some references to Zimbabwean law. And it's always a pleasure to listen to your presentation, as usual, down to earth with lots of practical examples that makes it easy to follow. Are there any questions to Inga Kichevska? If there is somebody who wants to ask something about small claims regulation or to make some additional comments on this one, now is the time. Again, as I don't see any questions, then once more, thank you for your presentation. Thank you. And then we are moving on. The fourth and the last presentation before our short break. We are a bit behind the schedule, but I think that's not a major issue, since we'll have one presentation less after the break. So the very last presentation is a group of researchers, 2 Germans and 2 Latvians. And
I'm giving ground to Edmunds Broks, who will start the presentation. Then Christoph Schewe will continue with the German perspective on the issue. And finally, I'll conclude the presentation with the Latvian perspective on the issue. So Edmunds, the floor is yours for the first part of our presentation.
Okay, thank you very much. Good afternoon, ladies and gentlemen. So can you see the slides and can you hear me well?
Yes, everything seems in order.
Okay, okay. So the topic that we are addressing is setting aside national rules that conflict EU laws. So I think this topic requires a bit of explanation. Why on earth are we dealing with an old judgment from 1978? But actually, it turns out that this topic is very much topical for Latvian courts, as Latvian courts are only now in the process of developing settled case law on situations where they find a clear conflict between Latvian national rules and EU law rules. So what are judges supposed to do? Are they supposed to refer such cases to Constitutional Court because that is the institution that can annul the problematic Latvian provision? Or rather, they are supposed to go to European Court of Justice, which after all is the ultimate authority on EU law, or perhaps they are to solve the situation by themselves and simply set aside the problematic Latvian rule on their own motion. So essentially, this is the question of who performs judicial review whenever you are faced with a collision between EU law rule and national rule. Now, Latvian Constitutional Court also hasn't been very clear on this, and so far it has kind of dodged the issue and hasn't really stated whether it is entitled itself to engage in constitutional review on the basis of EU law rather than Latvian constitution. So Siementhal is the case that pretty much answers these questions. And what we thought would be useful is to look how these very same questions are dealt with in Germany. And perhaps the German experience could provide a blueprint also for Latvian courts. Okay, so I think we could start with a little bit of context here. And the context is the classics of EU law. And I will just briefly remind them to you before we move on to dealing specifically with Latvia and with Germany, which are parts that will be done by Christoph and by Armis. Okay, so first of all, Siementhal is a preliminary ruling case from Italian judge in which the judge was faced with a situation of national rule, Italian rule, conflicting with a directly effective EU law rule. And in addition to that, Italian law provided that national courts are always, whenever they find some kind of discrepancy in national law, they are to refer the case to Constitutional Court, which will then properly annul the problematic national provision. So the question for the national judge is what I'm supposed to do. I have on the one hand directly applicable, directly effective EU law rule, and on the other hand I have this national rule, which is law of the land, and it's only the Constitutional Court who can sort of allow me not to apply that national rule. So that's the Siementhal case. And the context of EU law classics here, of course, is Van Ghent. As you probably all are well aware that Van Ghent says that EU law creates individual rights, and those individual rights must be protected in national courts. So essentially, for a direct effect of EU law, and Costa versus Eno provides for supremacy. If you have a collision between national and EU law rules, you apply the EU law rule. So what Siementhal does it brings these two fundamental constitutional doctrines together and spells out the details for national judges. So it says that every national court must apply community law in its entirety. And so this is the direct effect part, yeah, and protect rights which later confers on individuals. And secondly, must accordingly set aside any conflicting national law. So this is the supremacy part. Yes, it combines Van Ghent essentially with NL together. So the outcome of Cimental, what we could label as Cimental doctrine or Cimental rule, is that national law must not limit the power of any national court to immediately disapply incompatible national provisions. Okay, so Cimental does actually several things. One thing, it empowers national courts of all levels, and it takes away kind of the exclusivity of judicial review, which only the constitutional courts in many states can do. It takes away this exclusive power from the constitutional courts and gives it to all national courts, at least as far as EU law is concerned. Yes, so it makes essentially all national courts into EU law courts, which may be the reason why national courts have been willing actually to accept supremacy, which, if you really think of it, is, well, you could think that it's quite an outrageous proposition, since it wasn't even mentioned initially in the treaties. So that's Cimental, and over the years, European Court of Justice has pretty much stayed loyal to Cimental. It has repeated it in many judgments and also in quite recent judgments. But European Court of Justice has also developed other strands of case law. And here we have to specifically mention the indirect effect of EU law, also known as the duty of consistent interpretation, where national courts are under obligation to interpret national rules in light of EU law. So this obviously is an alternative to Cimental. Yes, if Cimental is quite rigid and it asks you to chuck out the national rule entirely, disapply it, indirect effect is kind of much more non-confrontational. You don't have to sound the alarm bells and shout that there's a problem in our national law, it's incompatible with EU law. You can kind of, without putting yourself in the spotlight, you can just quietly interpret away this problematic national rule in light of EU law. Okay, so you save time. You don't have to go to constitutional court. You can resolve the case by yourself from the perspective of national judge I'm talking now. And yes, it's just generally much more non-confrontational. But also it has a downside to it. Cimental is good in a way that you do solve the problem immediately, but without going to the constitutional court that annuls the problematic national provision. You leave the provision in place. And the same with indirect effect. Also, you leave the national provision intact. Okay, so systemically, the problem is not really solved. You just have solved the problem in your specific case that you have to decide. But the problematic rule remains, whereas constitutional review by the constitutional court kind of solves and fixes this problem in a systemic way also. So indirect effect has become for judges the preferred option for the above mentioned reasons. So in practice, we have seen Cimental sort of losing its appeal and perhaps being the second option after the duty of consistent interpretation. So this far, this is the general background. And now I would like to invite you to turn your attention more specifically to the experience of Germany and Latvia. And here I would give the floor to Christoph Scheele. Christoph, please.
First of all, thank you, Edmund, for this introduction of the whole problem. I will directly start with the situation of Simmental in Germany. And on the next slide, you will actually see the question, Edmund. The question in how far we think that German courts comply with Simmental. So actually, I will not really enter into specific problems with this issue because at first glance, it appears that we don't have a problem because there are basically two issues to be solved. The first would be, does a national judge have a problem with constitutional court? And we have provision, Article 100, paragraph 1 of the German Grundgesetz, the constitution, the basic law, which basically deals with a matter similar to Article 267, like the preliminary ruling procedure, so that courts can request the preliminary ruling of the Bundesverfassungsgericht, the constitutional court. And so if national courts think that there's a problem with the constitution, they will use this procedure. Secondly, if they think that there's a conflict with EU law, they would directly refer to the European Court of Justice or the CJEU. So that's the way according to the 267 TFEU. So it appears actually that judges are willing to use both procedures. Particularly interesting in our case probably is the second alternative. And when looking at statistics, for instance, the recent years, 2016 to 2020, it appears that German courts have been quite willing to use the preliminary ruling procedure. So among 2,768 cases, German courts have referred 564. That's more than 20%. So if you balance it with the size of Germany, the relative size, then I think it's a little bit over the percentage that Germany represents. And overall, it appears that courts, at least, they act according to the Simmental doctrine. But let's go to the next slide and see in how far we might have additional implications of Simmental. Because if you go beyond this paragraph 21 in the Simmental decision, then you also see a reference, which I shortened here. Anyway, you have a reference to administrative practice. This passage is not entirely clear, but when going into literature and comments on the Simmental doctrine, you already find the aspect that also national administration should apply the Simmental doctrine. And this raises a certain problem, because if it's already problematic, as Edmunds has pointed out, that courts, which under national law are not entitled to set aside laws, also because it would mean a breach of the separation of powers. Usually courts are to interpret rules and laws, not to set them aside. That's a part of the legislature. Then how about administration? Because the problem basically is so similar. They apply law, including European Union law, but if there's a problem with the full effect of EU law, then we would basically have the same problem as has been explained by Edmunds beforehand. So the question is, does the Simmental doctrine say something on this matter or not really? And basically, I would conclude at this point that Simmental indicates something, but the focus is on national court. But as we can see in the next slides, follow-up decisions of the European Court of Justice have dealt with this issue more in detail. Here, just a remark I couldn't help sparing myself because it was quite interesting from the point of view teaching at the University of Latvia before. I was searching for one decision which is relevant on the next slide, but here we could see that, could you go to the next slide, please, Edmunds? That we have a decision, Gervais-Lacy, where if you have a look at the English translation, that it refers that not only the lower courts, but all the courts of the member states are under duty to give full effect to community law. So you may wonder why I quote this decision here. This is because it is actually an incorrect translation from the original language was French, and in the original version, it says "met à toutes les instances de l'État membre," or in German language, sondern alle zuständigen Stellen des Mitgliedstaats. So this decision is directed not only at the courts, but the French instance means actually including administration and also legislation, that basic all institutions of the state are addressees of Simmental. So as we have seen beforehand, Simmental, or at least the follow-up decisions, expand the effect of Simmental, and accordingly, let's go to the next slide, please. One of the issues which are particularly interesting for Germany is the question whether the German administration also is aware of the implications of these decisions. Here in this slide, by the way, I quoted a different decision, basically saying something similar, because here we had Latvian translation of the judgment available. Could you go to the next slide, please, Edmund? So this is actually then the relevant slide for questioning whether the German administrative practice reflects the Simmental doctrine. And here, especially this conflict of EU law and the Simmental doctrine with the principle that according to the separation of powers, only the centralized system of Germany granting the sole power to set aside laws to the Bundesverfassungsgericht may become quite tricky. So the executive, meaning the administration, probably should not be entitled to set aside rules, because the separation of power would be even more encroached in that case. So how does Germany deal in practice with this matter? We have a system which is quite elaborated in a very detailed way, and administrative staff quite frequently does not work directly with the relevant laws, but with so-called administrative provisions or guidelines, which are actually binding. Those guidelines are pretty detailed, and the people working in administration don't have that much discretion for their decisions, and accordingly, they are bound by those provisions. This, however, is kind of invisible for the citizens, because they don't see usually the guidelines. They just get aware of the, become aware of the decision in form of an administrative act. And if they think that this administrative act is incorrect, then they can request a review either within the administrative procedure or at administrative courts. So the question is in how far those guidelines or administrative provisions reflect also EU law in the sense of Simmental doctrine. And this actually is guaranteed in a procedure that constantly the higher level of administration monitors and reviews those guidelines and make sure that the most recent judgments of the Court of Justice, for instance, are reflected, but also that new legislation is reflected here. And accordingly, the system also aims at complying to a very high level with EU law. And so far, I think we are safe to say that in all in all, the German system pretty much complies with the Simmental doctrine, even on the administrative level. This, however, is the overall tendency. Of course, there are problematic cases that may escape from the system, but I will not touch upon those problematic cases. And so I think we can move over to Latvia now.
Okay, finally, the last third of our presentation, as I see that we already covered 20 minutes of time, I'll try to be very brief, but I hope the listeners will be forgiveful towards us, since there are 3 of us, that we exceed slightly the time limit. So as a initial point, before I talk about Latvian experience, it was quite interesting in our cooperation project with the German colleagues, that what me and Edmunds started as an issue of constitutional court, and which still seems for us the most important issue for Latvian perspective on the Simmental. It does not look so from the German perspective, and from the German perspective, everything in relation to the constitutional court is crystal clear, but they have this problem with administrative level, which on Latvia, I would dare to say that nobody even gave a thought so far how Simmental works on the administrative level, and possibilities that the administrative instances do not apply national law and instead apply, set aside national law because of the EU law. So Edmunds, can you move to the next slide? So the brief version of the problem that Latvian legal system presents in the context of Simmental. There is the article in the administrative procedure law, which is devoted to the how the conflicts of law are resolved if there are different legal provisions that are contrary to one another. And what the article says, that if a administrative court, believes that a legal provision does not conform to the Constitution or provision act of international law, it shall suspend court proceedings in the case and send a substantiated application to the Constitutional Court. And after that sentence, the second sentence explains that when the Constitutional Court give judgment, then the case comes back to the administrative court, and the administrative court continues the adjudication of the case. Can you move to the next slide, Edmunds? If we take a look at the Constitutional Court law of Latvia, there is Article 16 of the Constitutional Court law, and in this article, seemingly we can find at least 2 grounds, in my opinion, that gives also a chance for the Constitutional Court to deliver judgments in such cases. So one option on which the Constitutional Court of Latvia could use is that there is a possibility for them to adjudicate the conformity of other laws and regulations which are not mentioned in the previous parts with the norms, acts of higher legal force. And we can interpret this that we talk here about Latvian law versus the EU law. And another possibility that the Constitutional Court law provides, another possibility for the Constitutional Court to adjudicate the matters of the national law against the EU law, is the paragraph 6 that says that conformity of Latvian national legal norms with those international agreements entered into by Latvia, that is not in conflict with the Constitution. So we can interpret the international agreements here really broadly, covering not only the agreements themselves, but in the case of the European Union, also the acts of the European Union institutions. So the problem here is that it, on the first glance, it contradicts the Simmental doctrine, because the Latvian administrative procedure law, read in conjunction with this article of the Constitutional Court law, provides the scenario that if the administrative court is faced with the situation when the national law contradicts the European Union law, then the Simmental would require for the administrative court to make a decision on their own, but those articles in the administrative procedure law and the Constitutional Court law provides a different route of action, and they required the administrative court to stop the proceedings, refer to the constitutional court, wait for the judgment of the constitutional court, and only then to continue adjudication of the court. How it's actually working in practice in Latvia. Maybe next slide, Edmonds. So in Latvia, in practice, the general practice of the Constitutional Court is that in general, Latvian Constitutional Court can be regarded as a really EU-friendly. And as early as some 13 years ago, even more, basically in the first decade of 21st century, there are some basics where the Latvian Constitutional Court acknowledges the EU directives and is saying that they are ready to use the directives as a tool of interpretation for the Latvian law. However, despite the fact that we are almost 20 years members of the European Union, so far there is a certain lack of clarity in the case law of the Constitutional Court regarding the possibility to review the Latvian norms solely against the EU law norms. So what happens in those scenarios when, for example, the national court, the National Administrative Court, would make a reference to the Constitutional Court? Is the Constitutional Court ready to give such a judgment and to evaluate whether the Latvian law evaluate the validity of Latvian law against the EU law? What is the practice of the ordinary Latvian courts? How they are reacting towards the Siementhal doctrine? That's the next slide. Can you move on at once? Yes, thank you. So far, there are no case law, at least I could not find any in any publicly available databases when there would be a situation that any judge would use this article 104.2, there's a mistake in the slide, it's not 3 but 2, part of the Latvian Administrative Procedure Law in EU law cases. And as a general tendency, Latvian courts actually try to avoid Siementhal case. I managed to find only 3 judgments that directly involve Siementhal case. And the general tendency is similar to that Edmund said, that Latvian courts prefer indirect effect. They prefer to interpret national law as much as possible in correlation with the EU law, but they try to avoid direct conflict, and they try to avoid Siementhal situations in which they should explicitly set aside the national law by themselves or by making a reference to the Constitutional Court and applying the directly effective EU law instead. That being said, the Latvian courts in general are really aware of EU law, and they are ready to use the EU law, which is confirmed by the activity in the preliminary rulings forum. The Latvian courts are the most active from all Baltic states in the preliminary ruling cooperation with the Court of Justice of the European Union. Can you move on, Edmund, to the next slide? As for the administrative guidelines, maybe since the time limit of our presentation is quite exceeded, I'll not go into details into that, but the general tendency is that what the German colleagues see as a problem in Germany, in Latvia, certainly there are no such cases so far that we could talk that there are some administrative bodies who are applying the Siementhal and who deliberately set aside valid national law and are saying that we are applying the EU law instead. And in the form of administrative guidelines, we cannot find anything like that as well. We'll certainly develop this part of the presentation on administrative guidelines in details in our article, since there are some general problems and some particular problems on the administrative guidelines on the EU law. But to conclude our presentation, let me just wrap it up and point out three main theses from our presentation. First of all, the part what the Edmunds covered confirms that the Simmental is still valid case law in the European Union law, although the follow-up decisions on Simmental put the emphasis from the direct collision to the indirect effect and to the possibility that the national court can use the interpretation instead of direct conflict. And this seems to be the case for Latvian and German courts, although for Germany in general, the Simmental case is crystal clear from the perspective of the Constitutional Court. At least the German Constitutional Court clearly divides the European Union law and the German law and are not interfering in any way in the EU law matters in a sense of constitutional review. As for the Latvia, this is slightly unclear whether we are also adopting the German model, whether that is the best solution for Latvia, and whether we should take into consideration some other factors as well. But in any case, a clarification from the Latvian Constitutional Court on all those matters would be highly welcomed, and hopefully it will come in one of the future cases. So this is the end of our presentation. Are there any questions, either to me or an Edmunds or to our German colleague Christoph? Yes, Christoph. Cannot hear you. Just
one additional remark, because there was one misunderstanding. The German Constitutional Court obviously sometimes has issues with EU law, but what I tried to present is the broad line. So in general, Simmental works pretty well. It is only in very, very exceptional cases that there are issues. But overall, if you consider the amount of disputes popping up every day in Germany for now over 60 years in the European communities, I think this is quite a success story overall. Of course, there are cases and there are sometimes issues. And last year, I think also in Latvia, we had a presentation also regarding the only decision by the Bundesverfassungsgericht so far, where it assumed that the Court of Justice of the European Union had assumed ultra virus implications in a judgment against the European Central Bank. And well, there are actually sometimes issues, but overall the system works.
Yeah. So my point certainly was specifically regarding the separation of the EU law and German constitutional law. And in that sense, Germany has this line cut. Of course, for the presentation, we talked about the situations when there's a national law and directives. And although there are some gray areas, but the general thing is that, yeah, for the Germany, this is the working practice for many years. Okay, maybe any other questions? If no, then we are taking a small break, and 5 minutes after that, that's 15 minutes before 4. Okay, maybe we have one question here. Then maybe we can cover this one quickly. There's a question, does the international actually covers EU law under the Administrative Procedure Law Article 104? And if it does, how should one read Article 4 Prim? Yeah, that's one thing I really hope that the Constitutional Court will clarify, because indeed in administrative procedure law in Latvia, it does not specify that it's the EU law. It just makes a broad reference to the international law. And I see that the international law in Article 104 can be interpreted in both ways, covering European Union law here and making an exception and covering only the traditional international law. Edmunds, maybe you have an additional comment on this one?
No, I think it's absolutely true that it's eventually up to Constitutional Court to come out and clarify this. I don't see a specific reason why you couldn't include under international law also EU law. So I think yes, it is eventually the Constitutional Court will be faced head on with a situation where they can't avoid it, and they will have to pronounce on this. And it's fine. It's fine. They really, I believe they really should say that it doesn't cover. You know, they really should say that it's not our job, because you should turn to European Court of Justice, and once you get the preliminary ruling from them, if you had any doubts, you apply Simmental and you set aside whatever is problematic in national law. The only issue that it remains unsolved is the systemic issue, because by reference to Constitutional Court, you sort of fix the system. You get rid of the problematic national provision, whereas by Simmental alone, it stays in place till the legislator takes it on, or Constitutional Court is faced in another proceeding with the same provision.
I'm on the same opinion that it should not, the Article 104 of the Administrative Procedure Law should not be interpreted as in a way that it contradicts the Simmental case. But whether it implies that the Constitutional Court cannot rule on the compliance of the Latvian law and EU law in other cases, that's a separate issue, because the Simmental talks about directly applicable EU law. And there might be some situations when for example, when there is a conflict between the national law and the EU law directive, and maybe it's not brought by courts, but by the group of parliamentary deputies. And that's again, a slightly different situation. So this is a really, really complicated issue here. And we can just hope that Constitutional Court will give some guidance on this. Okay, if there are no other questions, then we are on a short break, and I propose that 5 minutes from now we resume our proceedings. Let's say at 15:48. 15:48 we are back, and since Irena Kucina will not join us, then Alexander Spillers. Alexander, I hope you can hear me. Then after 5 minutes, the floor will be yours. Okay, the short break now. Tea break, and welcome back. I see that Alexander is already warming up his voice cords. So I'm giving floor to him. There are 2 presentations left in our afternoon session, and the first one comes from Alexander Spillers.
Thank you, Arnis. Can I share the PowerPoint? Okay, we'll just, yeah, is it visible?
Yes, we can hear you. We can see the slides as well.
Okay, 1 second. I will check the time. Okay. So thank you, Arnis, for moderating this conference, and thanks to the university for giving this opportunity, University of Latvia, for giving this opportunity to present topics for me, and I think for our colleagues, for my colleagues as well. It was very interesting to listen to the previous presentations. So my presentation is very much private international law presentation, really limited to this area. It's very much inspired by basically the teaching experience, just teaching private international law. I started to notice that some issues that seemed not very important when I did my own studies or my own research turn quite important once you need to really teach students, explain how private international works. And one of such things that seem to pop up in different hypothetical cases given to students is the concept of unjust enrichment. So the plan of the presentation will be first a few words about the concept of unjust enrichment itself, and then really going through the role and the place of unjust enrichment in a typical private international law context. First of all, conflict of laws. So the question which law applies to unjust enrichment if there is a cross-border element in the case, and then the jurisdictional part, specifically Brussels 1 bis regulation, how to determine jurisdiction for the claims based on unjust enrichment, claims for recovery of what other party has enriched itself. So let me start with a concept. I will not give a definition. Not myself such a really fan of defining things, but rather a few examples. But first of all, unjust enrichment is a concept that is both in the national legal systems and at the EU level. At least my perception is that it is somewhat lost in this antagonism or this dichotomy between contracts and delicts. So because these are the big categories, so unjust enrichment is lost somewhere in the midst. It exists, but often it's not really paid that much attention to. In the European Union, private international law seems to follow the same trend. So it's scattered across different legal instruments. And often the solutions found in those instruments are not really grouped in one place. They are really scattered also between different articles. So let me just give you, and I will explain that a little bit later with the Rome 1, Rome 2 examples in particular. Let me give you just a few examples of what could be unjust enrichment claims, where they could appear rather than define it. So these examples, some of them are more exotic, like a person has transferred money to the wrong receiver by mistake. Like R wanted to pay to person C, but instead there was some mistake and he transferred money to a different bank account. Or somebody overperformed under the contract, performed more than required. Or a person that has committed a delict overcompensated the victim. These are a bit more exotic elements, exotic situations, but there are more typical ones. These could be cases when the contract is found invalid or is avoided due to the breach. In these situations, again, you could have a claim for restitution, and that could also be covered by unjust enrichment. So this would also fall under the concept of unjust enrichment. So let me start by conflict of law rules situation and then continue with the jurisdiction. So it seems at the outset that the situation is very simple. Rome 2 regulation, Article 10 really has specific conflict of law rule for unjust enrichment and seemingly resolving all the problems. So if we combine that rule with Article 14 of the same regulation, we will find that there are following conflict of law solutions. First, the parties can choose the law applicable to the claims of unjust enrichment within the limits of Article 14 of the Rome 2 regulation. I will not go into details how much you can choose the law applicable in non-contractual obligations. So Article 14 provides for these limits, for these restrictions, but still in principle allows for the parties, to choose the law. If there is no such choice, then Article 10 offers three main solutions. If unjust enrichment is related to some other legal relation, for example, contract or delict, then regulation considers that it's better to submit all of that to one legal regime. So if unjust enrichment is, for example, a result of or connected with a contract, as in my previous example, where somebody overperformed, then the regulation says, determine the law applicable to the contract and apply that law to the unjust enrichment. It probably has some logic because to know that there is unjust enrichment, you first need to interpret the contract, understand what was the original obligation, and then probably it's better if the same law, it's easier for the parties, for the court, if the same law will determine whether you can claim something back, under what conditions what is the amount that you can claim back, etc. If there is no such underlying relation, this would, for example, be this case that I mentioned when somebody pays simply to a wrong person. There is a transfer of money to a wrong account. Then there is no underlying legal relation between the persons involved. Then the Rome II regulation offers two other rules. One, if the parties have common habitual residence, then the law of common habitual residence applies. And if common habitual residence is missing, then the law of the place of enrichment. Plus, as with many other rules in Rome I and Rome II regulations, there is a so-called escape clause, or manifestly causa connection clause, that allows the court to deviate from conflict of law rules, or conflict of law solutions proposed in Article 10, parts 1, 2, and 3, if there is some kind of manifestly causa connection with another legal system. So it's really the way for the court to take into account very specific circumstances of the given case. So this is what the Rome II offers, and it seems that this should be it. So on a conflict of law rule level, this should be the end of the story. Unjust enrichment is resolved. So the question is which law applies, at least that question is resolved. However, it turns out that, as I said, it's both in a national tradition and seemingly also at the EU level, it is scattered across different areas of law, different concepts, legal concepts. So unjust enrichment has this problem of being often associated with different things. And the problem appears also at the EU level, that Rome I regulation seemingly also deals with unjust enrichment. Notwithstanding the fact that it is Rome II that has a special article, still there is a place for Rome I. And in fact, the most typical cases of unjust enrichment seem to be covered by Rome I rather than Rome II. And this follows from Article 12, because Article 12, it's not a typical article you'd think you should look at when you decide what is the scope of Rome I regulation. Usually people would look at Article 1, civil commercial case, what are the excluded matters from the scope of the regulation. But Article 12 describes what specific issues are governed by the law chosen or indicated by the regulation. When the regulation indicates which law applies, what questions are covered by that law. And it seems that from Article 12, 2 points, one, that's saying that Rome I regulation determines consequences of the breach. And second one that says consequences of the nullity of the contract are determined by the law applicable under Rome I. We see that important elements of unjust enrichment are within the Rome I regulation. So my previous examples, if the party avoids a contract because there has been a breach by the other party, then the law applicable will be determined by Rome I regulation. This is also recently confirmed by Advocate General conclusions in the Just a Case, so in the conclusions that were just published in, I think, September. Or maybe in October, yeah, probably. Very, very recently. And so that's one thing. And the second example would be with nullity. So if the contract is invalid because of mistake, fraud, some other grounds, then again, what you can claim after that nullity is governed really by the law applicable and determined by Rome I regulation, not Rome II. This also poses an interesting question that is a bit side issue. I think it was already a little bit mentioned in a previous, one of the previous presentations by Professor Palasti, that there is a CISG versus Rome regulations. And indeed, since I followed the idea, it seems to me, the leading opinion that if we have CISG applicable to the contract, we do not apply Rome I, then in fact, if the question is about the avoidance because of the breach and the contract itself is governed by the CISG, then we don't really need the law applicable under the Rome I regulation because CISG has provisions on what to do when the contract is avoided. However, since the CISG doesn't deal with the nullity of the contracts based on its Article 4, if the restitution, which is another term for unjust enrichment, often used as a synonym, if the restitution problem appears because the contract is invalid due to the fraud, a mistake, duress, etc., then it would seem that we would need to find the law applicable under the Rome I regulation and apply that national law. So at the level of conflict of law rules, the unjust enrichment is simply divided between two regulations, although results of applying each of them is quite similar, because Article 10.1 says if unjust enrichment is connected to the contract, it's still the law of the contract that applies. So there is not a big difference. And so Rome 2, Article 10 would apply, for example, its conflict of law rule would apply, for example, if there is an overperformance under the contract. So the debtor has overperformed and wants to get back this part that has been overperformed. While if the contract has been avoided or is invalid, then restitution, the law applicable to the restitution is determined directly under Rome 1 regulation. With the Brussels regulation at the jurisdictional stage, the situation seems even more complicated, because we do not have, seemingly, we don't have a separate connecting factor, a separate rule to determine jurisdiction for unjust enrichment claims. There has been a suggestion by some authors, seemingly quite old suggestion, that it is Article 7.2, which determines jurisdiction for alternative jurisdiction for delicts, that should be also used for unjust enrichment claims. So basically, some authors say Article 7.2, it's non-contractual claims, not only delicts. However, this position has been not supported by the majority opinion among scholars. It doesn't seem to fall from the statements of the Court of Justice that have not been specifically so much on the issue, but indicating that Article 7.2 is really dealing with delicts, not non-contractual obligations in general. And in the recent Advocate General conclusions that I mentioned, there has been a very strong statement that the existence of the Rome 2 regulation, which itself divides delicts and other non-contractual obligations, including unjust enrichment, serves as a further proof that Article 7.2 cannot be seen as a specific jurisdictional rule for unjust enrichment claims. However, again, unjust enrichment then is just, there is no specific rule, but it's scattered throughout the regulation, and this makes it quite complicated. Okay, I will, for the sake of time, I will just briefly mention a few of them. So there is an opinion that indeed unjust enrichment is not covered by this in rem provision of exclusive jurisdiction provision, Article 24, Part 1, where it said that in rem rights on immovable property is an exclusive jurisdiction of the court where the immovable property is located, because it has been argued, I think quite with some persuasion, that unjust enrichment is not really an in rem, a property right. However, it seems that it could be within the exclusive jurisdiction if we are talking about tenancy of immovables. So for example, if the tenant claims overpaid rent for an apartment or for a house, then this could fall within Article 24.1 and exclusive jurisdiction. Okay, let me skip the second example and go, to save time, go directly to the most important things. There is, however, one article that does, to a large degree, cover many important, or these most important, maybe, aspects of unjust enrichment. These problems that appear once we have a contract avoided or contract invalid. So this is Article 7.1, which is really this alternative connecting factor for jurisdiction, in addition to the domicile of the defendant for contractual relations. And here the Court of Justice has clearly stated if the contract is annulled, there's annulment of the contract, and after that, or together with that, there is a claim for restitution, then this can all be put under this heading of in matters related to the contract of Article 7.1. So that this jurisdictional rule does apply to unjust enrichment. In the conclusions by Advocate General that I've mentioned already a few times, it is stated, I think, absolutely logically that this reasoning should be extended to situations when the contract is avoided due to the breach, or when there is an overperformance of the contract and there is a claim for the return. And while it's not very clear, there seems to be strong grounds because the formulations are very similar in Articles 10, 17, and 20, dealing with specific contracts. Article 10 deals with insurance, 17 consumer contracts, and 20 with employment contracts. They all start in matters relating to insurance, employment, consumer contracts. It would seem that if the contract itself falls under any of these rules, then probably claims for overpayment or result of annulment or avoidance should be covered by these provisions. And these provisions should provide jurisdiction as well for such claims. Then we also have the specific rule, Article 7.3, which is a very peculiar rule which specifically mentions restitution instead of unjust enrichment, but seemingly meaning the same thing, that if the civil case, so if there is a criminal case and under procedural law, the victim of this crime can also bring a civil action before the criminal court, and that court can also hear claims on restitution. Well, for example, the examples given is usually restitution of a stolen object. So this is a very peculiar specific rule, but also touching upon unjust enrichment. And of course, parties can always agree in their jurisdictional agreement, unless it's a topic covered by Article 24, exclusive jurisdiction. Otherwise, parties could, of course, agree in their jurisdictional agreement which court can hear the case on, including cases and questions of unjust enrichment. And that is, of course, if it's not stated clearly, then it's a question of interpretation of the jurisdictional agreement, whether it covers such claims or not. So for other cases, mostly it would mean that unjust enrichment not related to the contracts, for example, overpayment in case of the delict, or simply payment to wrong person, there, except Article 7.3, which very specifically when we're dealing with the criminal cases. Otherwise, we don't have, it seems that we don't have any special rule, and we are stuck with general domicile principle. So the regulation could have provided special rule for these situations, but it's not found. So, okay, after this running through these three regulations, what are the conclusions? So first of all, unjust enrichment is found in all three regulations. It would be logical that there is something in Brussels regulation and something in one of the Rome regulations, but it's even in all three of them. So while Rome 2 regulation seems to be the one that explicitly deals and uses the term and concept unjust enrichment, in reality, maybe even the most important cases of unjust enrichment connected to invalidity or avoidance of the contract are really dealt by Rome 1 regulation, quite counterintuitive solution. As to the Brussels 1 bis regulation, then it's very complicated because there unjust enrichment really doesn't exist as some kind of really single concept, but it's rather scattered across different jurisdictional rules. And we have to analyze each rule to see whether also it would cover claims for unjust enrichment. And it seems that if we look through these rules, that at the end of the day, if unjust enrichment is connected to the contract, then there are jurisdictional rules, in particular Article 7.1, but also some other, as I mentioned before. For unjust enrichment that is not related to contracts, seemingly there is no special rule for these situations, some kind of alternative jurisdiction, but the claimant will be obliged to use domicile of the defendant. So these are the conclusions on my side for now. In fact, when I started this research, I thought it will be easier. As I went through, I found it a bit more cumbersome and confusing, but I hope that it made some sense at least. Thank you for your attention.
Thank you, Alexandros. I guess that's the common difficulties researchers usually face when you start to think it's simple, but at the very end, it's not simple at all. But I think it was a really thorough presentation and you did a really fundamental research. And it just confirms that the fragmentation of law is quite a huge issue on European Union law on very many branches, be it international private law, be it consumer protection law. And that's the big issue with the EU law indeed. So are there any questions for Alexandros? Any questions, comments maybe? If there are no questions, then our last presentation, okay, we have one question from Inga and from Hannah as well. Hanna is our last speaker. Okay, Hanna, then maybe just a few minutes. We have a question from Inga.
No, it's not a question. It's just congratulations on Alexander's work.
Okay.
Thank you. Thanks.
I agree.
Alexander, I envy you. Nobody else got a special congratulations from the listeners, but you got it. Okay, if there are no other comments, then finally the last speaker, Hanna Kovačíková. I really hope that I did my best at Slovakian language attempt.
Yes, that's correct.
Then 15 minutes are yours.
Okay, thank you very much. I will try to share my presentation. First of all, I apologize that it's not on the recommended, in the recommended form, but our university has 100th anniversary this year, and we got obligation to present our new identity. So this is our new identity, Faculty of Law, Comenius University. And dear colleagues, I would like to present my presentation, which is relating to public procurement in these COVID times. The question what I am going to research and try to find answers is whether the COVID reason may be justification for uncompetitive procedure, procurement procedure, and whether Slovakia fulfills the conditions for this kind of procurement, which is set by the Commission. So as all of you probably knows, the market of procurement contracts are integral part of the internal market of the European Union, and therefore the principles which are ruled, which the internal market is ruled by, are also relevant for public procurement. The European Union provides regulation in the form of Directive on Public Procurement. It's number 24 from 2014. And this directive sets some goals which needs to be preserved and followed during the procurement. The most important one is to achieve the efficient use of the public funds, because this goal is not to just reach the cheapest price, but to reach the best value for money paid. And this could lead to the efficiency of public spending. So the public authorities should buy only those goods, works, or supplies which are the best for providing their public services. To serve or to achieve these goals, the effective tool how to achieve it is to use the most widened competition which is possible. And the directive presumes that only when there exists a genuine competition between the bidders, the best bid would be submitted for tender, and he will get the best value and best bid for its needs. Public procurement also follows the others or secondary goals, which are connected with the growth, which should be sustainable, smart, and inclusive. It shall also promote the participation of small and medium-sized enterprises into public procurement. And the last important goals, there are two, is the protection of environmental and to achieve societal goals, which means social inclusion of handicapped or excluded social groups. As I said before, the general rule for procurement is to procure goods, services, and works in the most competitive way possible. But directive also provides some derogations which lead to uncompetitive tendering. And there are also some conditions which needs to be fulfilled and which needs to be met. The first of all is that such procurement must be legitimate towards the task and competencies which the procuring authority enjoys when executing its task. That means that if the public procurer buy or purchases goods, services, and works which are not connected with its task, such procurement would be considered to be illegal or not correct. The other condition is that there need to be compliance with the procedure, which means that even when the public procurer is procuring in uncompetitive way, he needs to follow the negotiating process. He needs to follow principles of transparency, of non-discrimination, and he needs to try to achieve the best value for money. There is also need for legal background, which means there needs to be a legal act or provision in the specific law which entitles and stipulates the circumstances under which the public procurer could buy the needed items through this procedure. We can find this big legal background in Article 32 of the Directive on Public Procurement, and this article was also implemented into Slovak national law. I will talk about it later. And the last, but not the least important condition is the principle of proportionality, which means that if there are possible to use any other less uncompetitive tender methods, a public contractor must use such methods, which means that he can purchase goods, services, and works only in uncompetitive way only then when there are no other possibilities. And evaluation of such situation must be under the sound management. So he needs to behave as a most cautious economic operator who would not do in other way in the normal competitive environment. COVID-19 is a situation which surely can be considered a specific situation, and there exists also a legal background which enables public procurers to use it as an excuse for uncompetitive tendering. We can find it in Article 32, Section 2, letter C of the Directive on Public Procurement. But there are also some conditions, as you can see from my presentation, that require that it has to be the situation which is unforeseeable by the public procurer, and therefore there exists some urgency which is extreme, which are not enabling to use another methods in the serious time period, which are in competing methods lasting like 30 days or 15 days, if we are talking about various types of methods, and even not accelerating time periods, which can be shortened to 15 and 10 days. So there's another condition which needs to be fulfilled, that contracting authority is not the responsible subject for causing this urgency. That means that if the contracting authority, by its negligence, will cause the situation of extreme urgency, such procuring would not be considered to be legitimate if the contracting authority would use the uncompetitive method. As an uncompetitive method is considered to be a derogation from the general rule under which all purchases needs to be done competitively, such derogation must be interpreted in a restrictive way, and the procuring authority is the one who bears the burden of proof that there are no other less restricting possibility, and there are no other changes. How can he procure such goods, works, or services? As pandemic started, Commission quickly provided guidance how the contracting authorities should proceed in this area, specifically, which is aimed not for misuse of this type of procuring. And from this guidance, it is clear that Commission again considered it as a last possible possibility. How can the procurers could buy the goods, services, and works? Because in this guidance, Commission said or recommends to the contracting parties they should use firstly the negotiating procedures, with more potential distributors, and only if there are no available distributors who can manage the supply in a reasonable time, even accelerated in shortened period, only then there is a possibility for a contractor to award the contract directly to one selected economic operator. Before economic operator will be granted award, public procurer needs to do objective evaluation of the situation, and all of these circumstances which justify his procedure in this way needs to be recorded in a written form, and this evidence creates a part of the documentation to the public procurement to ensure that it will be reviewable later, and it's part how the public procurer can prove the transparency of the process. So how does Slovakia comply with these recommendations? That was the object of my interest. I checked all procurements from March 2020 until yesterday, and I filtered it with term COVID. So I realized that there was public procurement where the public authorities procured or bought goods, services, and works of the value more than 208 million. And from this amount, the procurements with value more than 130 was procured without tendering, and they were procured through the direct awarding. So they used negotiating procedure without prior publication. It's a huge number, and I was curious about the structure of the procurers who use these methods. And what was surprise for me, there was no hospitals amongst them. As you can see, there are mostly the public offices, but any hospitals in there. The most used the procedure was most used by the Ministry of Interior of the Slovak Republic. So it was a surprise for me. The question is if the conditions were met. Well, this question, according to my opinion, is connected with the time factor, because we need to deal with extreme urgency. And extreme urgency can be justified during the first wave because pandemic came like an unknown situation. It was very harsh situation in Slovakia. We were closed for maybe 200 days. But at the beginning, the stores were empty in Slovakia, medical stores. And that was the situation, extreme urgency, when the state needs to buy masks, by other medical staff, and the urgency was done. However, we expected the second wave, third wave, and everybody knew during the last summer that the situation still is preserving and will be worse. But surprisingly, Slovak authorities directly purchased another items of the amount of more than 103 million through the direct award. According to my opinion, the extreme urgency is really questionable in this matter, and therefore I think these types of awarding, direct awarding, was illegal and not complied with the public procurement rules. So what are my conclusions? Well, COVID-19 presents a reasonable justification for uncompetitive tendering, but there are some benchmarks which needs to be assessed and some criteria, and the public procurer must prove objectively and undoubtedly that it was an event unforeseeable by the contracting authority, that there is such extreme urgency that it is not possible to procure goods not even the accelerated period. There exists causal link between the unforeseen event and extreme urgency. And the other important criteria is that the goods or services procured through this type of procurement could just fill the immediate need and could not create reserves for the later period. It should be just the temporary solution for enabling the possibility to procure in a competitive way. What is the Slovak reality? As I have said, a huge amount of money was procured in the aim to provide health material for health protection. And more than 63% of this value was procured directly without competition. And what is worse, almost 80% of this amount was bought or purchased in this way in second and third wave. So therefore, my findings in this way is that COVID might be used as a justification for uncompetitive procedure, but in Slovakia is the way how it can be misused. Thank you very much.
Thank you, Hanna. COVID-19 is really hot topic in Latvia, as I'm pretty sure everybody noticed with the current lockdown. And public procurement, although I'm not an expert, but I've heard from several experts in the field, that's a big area of concerns in Latvia as well, and especially on those COVID grounds, as you mentioned it. Are there any questions for Hanna? If there are no questions, then once more, thank you, Hanna, for your presentation.
Thank you.
And with this, our session of presentations is over. However, there is one more item of on the agenda for our conference session. There are also two poster presentations which are available at the webpage of the conference. Are there any questions regarding those poster presentations? One of the authors of the presentation, Cindy Damberga, it was, if I'm not mistaken, she said that she had to leave early, but she's open to questions on her email. But as far as I can see, the virtual environment does not stimulate the pop-up of overly many questions. And then I guess with this, we can conclude our session. In my opinion, we had a really diverse and interesting set of presentations. And I really hope that everybody got at least something that was relevant for their daily job, or at least something that deemed really interesting. Thank you once more for all the presenters. And with this, we are closing our session. Goodbye.